Okay, maybe. Okay, there we go. All right, score. Hi everybody coming in. Tonight we are doing a live for Planned Parenthood v. Casey as promised. So we've been going over women's rights cases. We started with Griswold v. Connecticut. We did Eisenstadt v. Baird. We watched Roe. And now we're going to the point in history where they start making a whole lot of concessions on women's AB rights. So Planned Parenthood v. Casey rolls back some of the precedent established in Roe. Most keenly, that trimester framework of Roe, and kind of roll this back to more of a viability standard. And then part of the Pennsylvania law, which is what was being challenged here, said that spousal awareness had to occur. Just an interesting side note, out of Casey, they said you don't have to make your spouse aware that you are going to eat a fetus, right? However, but they did roll back this like sort of strict scrutiny we had to an undue burden standard, whether, states that make these laws, does it propose just an undue burden for a woman to not be able to have this take place. So we start seeing some of the precedent in Roe being stripped away in Casey. And then Friday, we are going to do Dobbs. But without further ado, this is Planned Parenthood v. Casey. Oh, thank you, Teddy. Hey, everybody coming in. Yeah, we're doing Planned Parenthood v. Casey. And I just also want to make a side note. A very good friend of mine passed away a year ago. Her name was Monica. A lot of you probably knew her on this app. She had cancer that spread to her brain and bones and lung. So please make sure that you are taking care of yourselves. Please make sure that you're getting yourself checked up the minute you know something's wrong. It doesn't always prevent things, but I just want the best for everybody. So we're doing this live tonight in memory of Monica. All right, guys, let's roll.
We'll hear argument now in number 91-744, Planned Parenthood of Southeastern Pennsylvania versus Robert P. Casey. 91-902, Robert P. Casey versus Planned Parenthood of Southeastern Pennsylvania. Ms. Colbert.
Mr. Chief Justice, and may it please the Court, whether our Constitution endows government with the power to force a woman to continue or to end a pregnancy against her will is the central question in this case. Since this Court's decision in Roe v. Wade, a generation of American women have come of age secure in the knowledge that the Constitution provides the highest level of protection for their childbearing decisions. This landmark decision, which necessarily and logically flows from a century of this Court's jurisprudence, not only protects rights of bodily integrity and autonomy, but has enabled millions of women to participate fully and equally in society. The genius of Roe and the Constitution is that it fully protects rights of fundamental importance. Government may not chip away at fundamental rights, nor make them selectively available only to the most privileged women. If the right to choose abortion remains fundamental as established in Roe v. Wade, the strict scrutiny standard is applicable. And as this Court found in Akron and in Thornburg, Pennsylvania's onerous restrictions must fall. Should this Court abandon strict scrutiny, as urged by the Commonwealth and the solicitor, not only might Pennsylvania's egregious intrusions on privacy stand, and a century of this Court's privacy decisions may also be dismantled. Equally disturbing, should this Court remove fundamental protection for the abortion right, women might again be forced to the back alleys for their medical care, with grave consequences for their lives and health. The Commonwealth argues that this Court may overrule Akron and Thornburg and abandon strict scrutiny and nevertheless preserve Roe's central meaning. While politically expedient, this view is certainly not based upon this Court's privacy jurisprudence. Every other brief filed in this case agrees that the protection offered by Roe's heightened scrutiny lies
you, Law.
at the core of this
appreciate you.
important decision. To abandon heightened review is to overrule Roe. This court has repeatedly held that the doctrine of stare decisis is of fundamental importance to the rule of law. Fidelity to precedent ensures that our law will develop in a principled and intelligible fashion, and that our guiding rules are founded in law rather than in the proclivities of individuals. Accordingly, this court has established that departure from precedent must be supported by some special justification. But no special justification exists here. Only 9 years ago in Akron, this court invoked the doctrine of stare decisis and expressly reaffirmed Roe v. Wade. Only 3 years later, in Thornburg, a case that is virtually identical to that before this court today, this court again found especially compelling reasons to reaffirm Roe and to find Pennsylvania law unconstitutional under the standard of strict scrutiny. Nothing has changed since that time. Indeed, millions of women continue to rely on the fundamental rights guaranteed in Roe v. Wade. The medical conditions that led this court to create and establish these fundamental rights remain the same. This case, the statute, the parties are nearly identical to those in Thornburg. Never before has this court bestowed, then taken back a fundamental right that has been part of the settled rights and expectations of literally millions of Americans for nearly 2 decades. To regress now by permitting states suddenly to impose burdensome regulations or to criminalize conduct would be incompatible with any notion of principled constitutional decision-making. Roe is both soundly based in the Constitution and sets forth a fair and workable standard of adjudication. From as early as 1891, this court has recognized that the rights of autonomy, bodily integrity, and equality are central to our notions of ordered liberty. Roe lies at the heart of those interests. While pregnancy may be a blessed act when planned or wanted, forced pregnancy, like any forced bodily invasion, is anathema to American values and traditions. In the same way that it would be unacceptable for government to force a man or woman to donate bone marrow, or to compel the contribution of a kidney to another, or to compel women to undergo abortion or forced sterilization.
This is an attorney. Her name is Catherine Colbert, which is super interesting because that's very close to my maiden name. I just thought that was funny when I heard I thought I heard it wrong at first, and I thought it was my maiden name. They were saying I had to go look. But yeah, this is Catherine Colbert, and she is slaying on the mic.
Our Constitution protects women against forced pregnancy. If anything, because forced pregnancy will jeopardize a woman's life or health, the constitutional protections ought to be greater. The solicitor tries to draw a distinction between constitutional protection against forced abortion, which he agrees is fundamental, and constitutional protection against forced pregnancy, which he maligns. But once this court removes fundamental status from the abortion right, there is no logical stopping point. Fundamental status for all reproductive rights, decisions about birth control, pregnancy, sterilization, even high technology around reproduction may also be jeopardized, particularly where there is no bright...
Let me just point this out real quick. I think this is 92 or 93 this case is being argued, if I'm correct. I'd have to go back and look, but I can't exit because I can't get back to the same place. Okay, so this is 92 or 93 this is being argued. Roe was argued in they just kind of made a decision in like 76, 77. So about 20 years for them to roll back the scrutiny standard from Roe, the transition from the trimester framework to the viability standard. Probably the only fucking decent thing to come out of Casey was, Pennsylvania saying you have to tell your spouse is like, it's against the 14th. Like they can't make you do that, right? So Casey rolls back in 20 years, and then it took 30 years for them to just be like, fuck all this precedent. She's not wrong. I thought it was 70. Dang it, law. I love you. Okay, yes. Law said it was 72 for Roe and decided in 73. My bad. I apologize.
Line between abortion and some methods of birth control.
About 20 years.
Fundamental right both to prevent pregnancy and to end pregnancy may be at stake. Our nation's history and tradition also respects the autonomy of individuals to make life choices consistent with their own moral and conscientious beliefs. Our Constitution has long recognized an individual's right to make private and intimate decisions about marriage and family life, the upbringing of children, the ability to use contraception. The decision to terminate a pregnancy or to carry it to term is no different in kind. Both the solicitor and some Commonwealth amici argue that the Constitution only protects private decision-making within families. It is true that the rights of privacy have been recognized in the familial context. For example, in Griswold, the court found unconstitutional the Connecticut statute that prohibited married persons from using birth control. And in Loving, this court found invalid a Virginia statute that prohibited the marriage of interracial couples. Nevertheless, this court has never limited the notions of privacy recognized in these cases as only arising or belonging to married couples. Indeed, in Eisenstadt and in Carey, this court specifically rejected this view. Nor can this court alter its historic recognition of privacy and deny women fundamental freedoms because, as the solicitor argues, the woman is not isolated in her privacy. Surely, if the government cannot require individuals to sacrifice their lives or health for others or for other compelling purposes, it cannot require women to sacrifice their lives and health to further the state's interest in potential life.
Ms. Colbert, you're arguing the case as though all we have before us is whether to apply stare decisis and preserve Roe against Wade in all its aspects. Nevertheless, we granted certiorari on some specific questions in this case. Do you plan to put any of those in your argument?
Your Honor, I do. However, the central question in the case is what is the standard that this court uses to evaluate the restrictions that are at issue? And therefore, one cannot...
Well, the standard may affect the outcome or it may not, but at bottom we still have to deal with specific issues, and I wondered if you were going to address them.
Yes, I am, Your Honor, and I would like in particular to address the husband notification provisions. But the standard that this court applies will well establish the outcome in this case for a variety of reasons. This court has already found that under the principles of Roe versus Wade, the bulk of the Pennsylvania statute is unconstitutional. There is no question that this court struck down as unconstitutional under strict scrutiny the bias counseling provisions and the 24-hour mandatory delay, both in Thornburg and in Akron, the case in 1983. And therefore, this court must examine first the question of what's the appropriate standard before determining the constitutionality of those other provisions. The court cannot alter its historic recognition of privacy and deny women fundamental freedoms, as I was speaking, because, as the solicitor argues, there's the presence of the fetus. Surely, if the government cannot require individuals to sacrifice their lives or health for human beings who are born for other compelling purposes, they cannot do so for purposes of protecting potential fetal life. And if this court is to reduce the presence of a constitutional right merely because of the presence of the fetus, other childbearing decisions, whether they be the right to carry the pregnancy to term or make other childbearing decisions, will be particularly affected. Particularly here, as this court noted in Roe, where there is widespread disagreement in both a philosophical and a religious sense about when life begins. This court cannot sanction one view to the detriment of women's lives and health.
That fucking part.
Nor can the state of the law in 1868 define or determine constitutional rights for all future generations. This Court must look generally to whether a right is reflected in our nation's history and traditions, rather than at whether the activity was illegal at the time of the adoption of the 14th Amendment. Relying exclusively on what 50 states have legislated in determining the scope of liberty would imperil numerous freedoms, such as rights recognized by this Court in Brown, Bowling, Griswold, and Loving. This Court has also recognized as...
Mrs. Colbert, on this last point, I'm not sure what you suggest we look to. You say we should not look to what the practice was in 1868. Should we look to what the practice was at the time of Roe, or what the practice is today? That is, what the states would do, left to their own devices?
Your Honor, I believe that you have to look very generally at whether the nation's history and tradition has respected
Barda, I'll be honest with you. I haven't watched almost any of that. I'm just waiting to see the verdict on it. I think we all know what it's going to be. Like, I don't even know. Are they still in motions? Have they actually gone to trial, Barda? Like, I honestly don't know. I get weird updates every now and again, but I haven't seen anything.
They're in pre-trial right now.
Okay. Yeah, I knew there was some stuff going on, but I was like, I have no idea what's happening. Is it going to be on the air? Like, is Court TV going to show it? Does anybody know?
I don't think it's being broadcasted.
Okay. Yeah, so if I can't watch it like that, it's kind of hard to sit there. Oh, you've been seeing clips all day, Preacher? Well, shit. I'll go check Court TV after this, y'all. Get back on this argument because Catherine is friggin' slaying.
Interests of bodily integrity and autonomy, and whether there has been a tradition of respect for equality of women. Those are the central and core values.
But not to abortion in particular.
Well, this Court is if the Court was only to look at whether abortion was illegal in 1868, that is, at the time of the adoption of the 14th Amendment, it would be placed in a very difficult situation because at the time of the founding of this nation, at the time that the Constitution was adopted, abortion was legal.
Well, pick 1968. I gather you wouldn't accept 1968 either, though.
Well, we think that the Court ought to look generally at the principles that this decision protects, that ought to while it is important to look, and I would not urge you to ignore the state of the law at different periods of our history. It is only one factor in a variety of factors that this Court has to look to in determining whether or not something is fundamental. And fundamental status in this instance derives from a history of this Court's acknowledgement and acceptance that private autonomous decisions made by women in the privacy of their families ought to be respected and accorded fundamental status. Certainly, the anomalous posture of the fact that abortion was legal at the time of the founding of the Constitution and then illegal at the time of the adoption of the 14th Amendment would place this Court in a very difficult position that his rights may be guaranteed under the...
All I'm saying is all of these men out here heeing and hawing about, women, blah, 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 blah. It's a life. Fucking, I don't ever want to see them do shit if they get a parasite. I said what the fuck I said. They better keep that worm.
The Fifth Amendment and not the 14th, merely because only the exact state of the law in 1868 is the factor that the Court accepts.
This is not an antiquarian argument you're making. I mean, you would have made the same argument in 1868. I think you would have said the mere fact that most states disfavor of abortion is no justification for this Court's saying that it is not therefore included with it. You would have made that same argument in 1868. I
would, and that is the argument that this Court has made in many instances in rejecting exactly the state of the law prior to the granting of fundamental status. That is, this Court, if we were only to look at whether state legislatures prohibited activities in determining whether or not an activity is fundamental, many of the most precious rights that we now have rights to travel, rights to vote, rights to be free from racial segregation, would not be accorded status because, in fact, state legislators have acted to inhibit those rights at the time of the adoption of the 14th Amendment.
Some of those are mentioned in the Constitution, like racial segregation.
Your Honor, this Court has recognized that the rights at issue here, that is, the rights of privacy, the rights of autonomy, flow from the Liberty Clause of the 14th Amendment, which is also mentioned in the Constitution. The debate centers on what is the meaning of that term liberty, and we think that the precedents of this Court that began at the end of the 19th century and have proceeded from this Court to the very present logically and necessarily include fundamental rights to decide whether to carry a pregnancy to term or to terminate that pregnancy.
I don't question the importance of your arguing that there's a fundamental right, as you've done. However, there's a fundamental right to speech, and we hear any number of arguments in this case on time, place, and manner. I don't think our decision on parental notice in the Akron case is necessarily inconsistent with a fundamental right, but one way of our understanding this fundamental rights, and their parameters, their dimensions, is to decide on a case-by-case basis. And you have a number of specific provisions here that I think you should address.
The critical factor is whether, as a result of its fundamental status, this Court will accord the standard of Roe, that is, strict scrutiny. Because under that standard, there is no dispute among the parties. Under that standard, the bias counseling provisions, the 24-hour mandatory delay, have been found unconstitutional. And significantly, this Court has also gone so far as to say that the husband consent requirements, very similar to the husband notification requirements at issue in this case, have also been found unconstitutional.
Like, if you're not aware, one of the, only decent things to come out of the Casey decision was that they said that having to notify your husband did not jive with the 14th Amendment. But the other stuff she was speaking to about the 24-hour wait, and they were like, nah, all that's cool. So if you're coming in, we are watching Planned Parenthood v. Casey and the slow rollback of demolishing women's rights in America. So I love that for all of us.
I'm suggesting that our sustaining these statutory provisions does not necessarily undercut all of the holding of Roe versus Wade.
It is our position, Your Honor, that if this Court were to change the standard of strict scrutiny, which has been the central core of that holding, that in fact that will undercut the holdings of this Court and effectively overrule Roe versus Wade. To adopt a lesser standard, to abandon strict scrutiny for a less protective standard such as the undue burden test or the rational relationship test, which has been discussed by this Court on many occasions, would be the same as overruling Roe. For it is the beauty of Roe, the protections of Roe, flow from the fact that this Court gives, upon a proof that particular state regulations interfere with the right, Roe establishes and creates a burden on government to come forward with a compelling purpose.
Well, if you're going to argue that Roe can survive only in its most rigid formulation, that's an election you can make as counsel. I'm suggesting to you that that's not the only logical possibility in this
Fucking
case.
Kennedy.
Our position is that Roe, in establishing the trimester framework, in establishing strict scrutiny, and in also establishing that the rights of women and the health interests of women always take precedent over the state's interest in potential life. Those hallmarks of Roe are central to this case and are central to continuing recognition of the right as fundamental. Should the Court abandon that?
Did the Court hold that even after viability of the fetus in Roe? Do you think that was a correct characterization of Roe's holding that you just gave? That the woman's interest always takes precedence? Is that true under Roe?
Your Honor, under
the latter
Roe,
stages of pregnancy?
after the point of viability, that is the point when the fetus is capable of survival, the state is free to prohibit abortion, but only so long as it is necessary, or only so long as the woman's health interests and life interests are not at stake. That is, potential fetal life is a recognized value, is a recognized state interest after the point of viability. But when in conflict, when the woman's health interest is in conflict with those state interests in potential life, those women's interests, the women's interests in health, take precedent. Now, admittedly, the question of viability and the viability line is not as present in this case as it has been in many of the other cases that this Court has seen before here. That is, all of the restrictions that are at issue in Pennsylvania attach in pregnancy at the very beginning of pregnancy, and therefore the state's interest in protection of fetal life really does not come into play. The real issue is whether or not these health interests, that is, whether or not the state's interest in protecting compelling interest in health, are present. And frankly, this Court need only look to the record. That is, need only look to the findings of the district.
Here's the bottom line. Listen, states can fucking dick around with this all they want. Pre-viability, and I'm going to be super, super broad here, and we're just going to call it at 20 weeks, right? And even like between 20 and 20, you're really flirting a real line there. But here's the thing. Pre-viability, what is their narrow and tailored interest in protecting that? It makes no sense. And the only thing that they can offer up is like, well, it's, life at conception. Okay, like, and what's your point? Like, the state being able to regulate this has resulted in not only women, but also babies unaliving. That is the whole point.
Court to determine that this statute in no way furthers women's health interests. That in fact what this statute does is cause a detriment to women's health, submit her to increased dangers as a result of delay, as a result of interference with the doctor-patient relationship, as a result of permitting third parties who would injure individuals who are required to give husband notification, that those interests in health are not furthered in any respect. The Commonwealth attempts to characterize the restrictions at issue here as reasonable. For the woman who, as a result of mandatory husband notification provisions, will be beaten or will see her children beaten, the restrictions are not reasonable. For the woman who must travel 200 miles on 2 and 3 occasions as a result of the Act's mandatory delay, the restrictions are not reasonable. For the woman who has become pregnant as a result of marital rape, obtaining information from her doctor that her husband may be liable for child support is both cruel and oppressive. They are not reasonable. To find these restrictions reasonable, this Court would have to ignore the facts placed in evidence in this case, which demonstrate that the restrictions were not enacted to improve women's decision-making or health care. After listening to the testimony of 10 witnesses, including those proffered by the Commonwealth, the District Court made 387 findings of fact and repeatedly concluded that the Pennsylvania restrictions will interfere with the ability of physicians to provide quality medical care and will delay and discourage the performance of abortion to further no legitimate state interest. In particular, the lower court found that the mandatory husband notification provisions will have dangerous and potentially deadly consequences for battered women, likening forced notification in a battering situation.
And before I get some chud in this comment that I will block if you fucking start this shit, let me be clear. A lot of abuse is just never reported. I hate the comment, oh, it's just like it's a small set of scenarios. a lot of abuse is never reported. A lot of assaults are never reported. So when you say shit like that, you just sound dumb. Thank you so much.
To providing the husband with a hammer with which to beat his wife.
Was the husband notification provision the one that the Court of Appeals held unconstitutional?
It was, Your
And
Honor.
it upheld the balance of the act. Is that correct?
That's right. The district court found as well that biased counseling provisions transform the physician from the impartial counselor mandated by accepted medical standards into a partisan proponent of the state's ideology, and mandatory delay will increase both the expense and medical dangers of abortion, yet furthering no legitimate state purpose. There is no serious contest about the effect of this law, nor can there be, for under Rule 52, the district court's findings are not clearly erroneous. Nor did the fact that this is a facial challenge require petitioners to prove that the statute cannot be constitutionally applied to any person. This court has repeatedly found statutes facially invalid after looking at facts like those present here. For example, in Hodgson, this court relied extensively on district court findings to strike down Minnesota's two-parent notification statute with no bypass, despite the fact that that statute had never yet been in effect. The extensive record here demonstrates that the harms are not speculative nor remote, nor is this a worst-case scenario.
Okay, so what they had to do, I wanted to make sure I did this correctly. What they had to do was they had to sign a statement that they notified them. That was what was required. Most people, I wouldn't say that anymore, but at least I would hope people aren't signing things and attesting to things that they didn't do. So it gets very problematic. You blame Susan Collins for what? This is Pennsylvania in 1992. Thanks a lot.
The court should not demand an unwanted child or a woman maimed by an illegal abortion as proof that strict scrutiny is applicable. Pennsylvania women should not be the guinea pigs in the state's experiment with constitutional law. To find otherwise would totally eviscerate the strict scrutiny standard of review and would prevent federal courts from scrutinizing legislative findings, a central role in the process of judicial review. Let me turn now specifically to the husband notification provisions. There is little doubt that these provisions violate the fundamental right of privacy, marital integrity, and equality. Beginning as early as Danforth, this court recognized that a husband cannot arbitrarily veto the childbearing decisions of his wife. Like the Missouri law at issue in Danforth, state-mandated communication between husbands and wives violates the autonomy of married women to make personal and private decisions. Particularly here where a married woman is often the survivor of marital rape and where the penalty for transgressing her husband is likely to be physical violence against her or her family members, government has the obligation to respect her private decisions, not to involve her husband. The solicitor dismisses the import of the state-imposed harm and believes or claims that the Constitution is not intended to remedy them. But this approach seriously ignores that women will be seriously maimed and that harms will be invoked. And it's a callous disregard for their lives and health. While it may be desirable for husbands and wives to share intimacies in their daily life, the concepts of this court developed in the principles of marital integrity ensure that the government cannot decree for those couples how that communication should occur. That to decree and direct family life is more destructive of family integrity than permitting families to resolve their differences on their own terms. The husband notification provisions also violate principles of equality. These are provisions that apply to women and women alone. Imposed notification gives a benefit only to men, and as such, they violate the dictates of the Equal Protection Clause. The legislative scheme that assumes that husbands are capable and authorized to make all independent decisions but wives are not, reflect an outmoded common law view that women once married lost their legal identities to their husbands. In the days before Roe, thousands of women lost their lives, and more were subjected to physical and emotional scars from back alley and self-induced abortions. Recognizing that, this court established Roe and established fundamental protection for women's childbearing decisions. We urge this court to reaffirm those principles today, to adopt the rulings of this court in Akron and Thornburg that use the Roe strict scrutiny standard, and affirm in part and reverse in part the judgment of the Court of Appeals. I would like to reserve 3 minutes for rebuttal if there's no further questions from the court.
Very well, Ms. Colbert. General Preet, we'll hear from you.
Mr. Chief Justice, and may it please the Court, this Court granted certiorari on the question of whether 5 sections of our Pennsylvania Abortion Control Act are constitutional. It is the position of Pennsylvania that each
I want everybody to just roll back real quick to that name. The Pennsylvania Abortion Control Act. Just let that sink in for a minute. And we're about to hear this chode argue that, like, they're not violating people's fundamental rights. I love this for all of us. Let's take a journey, everybody.
each of the 5 provisions is constitutional under the analysis that was applied by this court in Webster. And further, Roe v. Wade need not be revisited by this court except to reaffirm that Roe did not establish an absolute right to abortion on demand, but rather a limited right, subject to reasonable state regulations designed to serve important and legitimate state interests.
Mr. Attorney General, I'm not so sure that's so important. Roe itself said that.
That's correct.
This does not provide for abortion on demand. Have you read Roe?
Yes, I have.
Thank you.
In our view, the accommodations of the woman's right and the state's legitimate interest in the unborn child is best served, short of overruling Roe, by employing the undue burden standard for reviewing state abortion regulations. However, as we argue in Part 2 of our brief, if our statute cannot be upheld under the undue burden standard, Roe, being wrongly decided, should be overruled. I'll now address the specific provisions of our statute and start with the requirement of spousal notice.
He just told him, like, if we don't get undue burden, fuck Roe. Like, that's all he just said to them, because it was a strict scrutiny analysis, I believe, and they want to move to undue burden. Like, does it create more of a limitation than, like, needed for, you know, women to access this? And he was just like, basically like, if we don't get this, fuck it. Just fuck Roe. It was wrong. And he just came in saying, like, we're not challenging Roe. We're not fucking, I swear to God. Okay. I'm going to stop ranting. We'll listen.
Notice, which was the only aspect of our law that the Court of Appeals found unconstitutional. It's important to remember, and perhaps more important than in this context than any other, that the petitioners brought this action as a facial challenge to the statute. In this kind of a challenge, it's enough for the petitioners to show, it's not enough for them to show that the act might be unconstitutional as applied to someone in some hypothetical worst-case scenario. Rather, the petitioners must show that the statute could not constitutionally be applied to anyone. We ask, have they met that burden? And we submit that they have not met that burden. This is a spousal notice provision. It is not a spousal consent statute.
Now, the provision does not require notification to a father who is not the husband, I take it.
That's correct.
Or notice if the woman is unmarried.
Yeah, because husbands never
only
beat
applies
their
to
wives.
married women.
Mm-hmm. So what's the interest? To try to preserve the marriage?
There are several interests. The interest, of course, of protecting the life of the unborn child.
Well, then why not require notice to all fathers? It's a curious sort of a provision, isn't it?
It is that, but the legislature has made the judgment that it wanted its statute to apply in this specific instance because it wanted to further the integrity of marriage.
Would you say that the state could similarly require a woman to notify anyone with whom she had intercourse that she planned to use some means of birth control after the intercourse that operates, let's say, as an abortive fashion?
Well,
could the state do that? I mean, it would be the same state interest, I suppose.
The state interest would be the same, but I think that would be problematic. I'm not.
And why would it be problematic? Do you think?
I think that with regard to applying a statute to all women, it might create a severe obstacle, an absolute obstacle to their obtaining an abortion.
I don't understand.
The undue burden standard, as I understand it, is that whether or not the regulation would impose such an absolute obstacle, whether it would deter or inhibit some women from obtaining an abortion.
We're talking about the provision for notification in this case under the statute.
So think about what he just said. Was that, like, this provisions in their act, or hypothetical ones, are indeed, like, it's called the abortion control. Their whole goal is to prevent people from accidents. That's why, like, their change to undue burden is crazy for me.
The husband. And I'm just asking whether a different type of state regulation would have to be upheld under your standard.
Well, if the state had posited its interest as protecting the life of the unborn, then utilizing the rational basis standard that I would submit, that it could legitimately require that kind of notification to all people. In this instance, however, we have a different statute. We have a statute that provides exceptions where exceptions are appropriate. There are 5 of them. Medical emergency, where the husband is not the father of the child, where the husband cannot be found, where the pregnancy is the result of a reported sexual assault, or where the woman in her judgment believes it's likely that she will be physically abused. Now, petitioners have produced some testimony and made some argument, essentially through one expert about battered wives. But the testimony was that some unknown number were rendered so helpless by their battering husbands that they were incapable of checking off the line on the form, the spousal notice form. We can agree that these women are indeed cruelly burdened, but they're not burdened by the statute, and that's the compelling point. They're not burdened by the statute, but by the circumstance and the tragic circumstance of their lives. We're looking at the statute to see if the statute imposes the obstacle. If there is a battering husband that's interposed in there, that's a different story.
What's our standard on a facial challenge? Whether there's a substantial...
Like, this is where my questions start to come in. And here in a minute, I'll try and look this up and find out. Let's say the woman goes ahead and signs this, doesn't inform the husband that this took place because he's a spouse, a wife beater, or whatever, right? Let's say she does this. She signs this form that's required for her to sign, saying she notified them. First of all, you're lying on a form. That's a whole issue that you're, attesting to this. But then, could the husband then sue his spouse? I mean, does she just get beat to a bloody pulp? Like, what's going to happen? What if he becomes aware? Because, if you're not aware of this, an AB is not just something that, you're good when you leave the office. A lot of time, sometimes there's a pill form involved, sometimes there's a DNC, but either way, you're not going home and just being like, I'm ready to go. There's pain involved. There's other things involved. So I'm wondering if he becomes aware after and she signed this form, is there penalty? I'm wondering how that would occur. Hi, Attorney But yeah, so we're about halfway through Casey right now.
Substantial likelihood of the harm?
No, I think you have to ignore what the petitioners have posited, which is a worst-case analysis scenario, and you have to look and see if it could be constitutionally applied, validly applied to anyone. And we submit that in this particular instance, the record reflects that right now in Pennsylvania, 50,000 abortions, 20% of those women are married, and 95% of those women notify their husbands. Therefore, only 1% of the women are not in Pennsylvania notifying their husbands now.
So then why the fuck do you need it in the first place? I'm sorry. Okay. So Attorney Di, give me just 1 second because you're coming into this. They're talking right now about the provision in the Pennsylvania law that said that like married women had to notify their husband if they were having this abortion, right? So he's like sitting here saying that, 20% of these abortions are already married and like 95% of them notify, already. Then I'm like, why do you even fucking have it in there in the first place? That makes no sense. If they're already doing it, why are you concerned? Also,
That's a really good point. What's so fascinating about this case as it keeps rolling along is that it's all about other people being involved, right? Because the woman's like, man, I'm not going to say anything to parent or brother or husband or whatever. So it seems like there's like this comparison between who really should be involved in knowing or should they not be involved in knowing. So I think that's where we get a couple more walks down the road with the privacy issue. Also, lest we forget, Alito was against this decision.
not Alito. That's crazy shit.
I know, right? He said it wasn't
Trigger,
strict enough.
what the fuck are you talking about? There's a lot of things I'll say I've said, but never drop the N-bomb. So thanks so
Hey,
much.
Trigger, are you talking about me? Because I had to go on there and get a few things cleared up too.
I don't think you dropped the N-bomb though. I was here. I was there. So I don't think you did that. But whatever. He's just in here starting shit and trying to get us off track. But yes, anyway, so we're about halfway through Casey right now. And I'm hearing this chud be like, we're not trying to really like challenge Roe, but if you don't roll it back from strict scrutiny to undue burden, just fuck Roe altogether. Like, this is wild. And
perfectly said.
He's big mad at Miss Sandra Day O'Connor. So I love that for her. She's on their neck. I'm here for it. Okay, we'll get back into it.
It's not even in effect. There is no broad practical effect in the Pennsylvania statute to prohibiting abortion for those women. The act goes into effect. Some of those 1% of women will then have to notify their husband. The result will be they will resolve their difficulties amicably. There will be some who will then take the exception because they don't want to notify their husband. They may be battered. There may be a spousal rape. There may be they can't find the husband. So what we're doing is reducing that set of women down into several subsets. And the petitioner's burden in a facial challenge is to establish, see that there's a broad practical impact.
No,
they have not met that burden.
May I ask you a question? Is it not true, therefore, that the only people affected by the statute, this very small group, are people who would not otherwise notify their husbands?
I'm not sure I got all of the question, Justice.
Well, you've demonstrated this, that the public interest is in a very limited group of people, the few women who would not otherwise notify their husbands. And those are the only people affected by the statute.
That is correct.
Everyone in that class, should we not assume, would not notify her husband but for the statute.
That is correct. In that 1%, not everyone would want to notify, and there are exceptions.
They would not without the statute.
They would not without the statute, but there are exceptions. There's several of them, 4 of them.
No, you've already taken the exceptions into account in narrowing the group very to 1% or whatever it is.
Justice
You aren't suggesting there's no one whose decision will be affected by the statute.
Well, that's the point. On this record, which is what we have to go on, there is nothing established by the petitioners.
Well, if there's no one affected by the statute, what is the state interest in upholding the statute?
The state interest in upholding the statute is the protection of the life of the unborn and the protection of the marital integrity, and to ensuring of communication, the possibility. We're not asking
but
not
if the statute has no effect.
I swear to God, we were just like, if you're coming in right now, we were just talking about that, and I'm like, if it only affects like this 1%, why have it in the first place? Who fucking cares? And the second part would be, I always hate the approach of like, well, we're just trying to make sure that this like 1% of the 1% of the 1%, don't get shafted. Look, if you're married to a woman, like married, not just you're dating. This applied to people who were married. If you're married and your spouse can't trust you enough to tell you that they are having a problem and that something is going on and that they feel this is the right decision for them, that's on you, baby. Y'all have more serious issues than whatever fetus she's uterusing. I want to be so fucking clear here. That's a you problem. There's also women, spousal abuse, spousal rape, things like that are way underreported. So, yeah, just that's a y'all problem. And to their point, this has absolutely no purpose if it really doesn't affect anyone.
As a general
matter, a lot of
matter,
times too, in the husband and wife back and forth that happens. Sorry, I had to get my box of popcorn. But in the back and forth that happens when you're married too, I mean, your husband might like be really uncomfortable talking about health stuff, or maybe it's not his kid. Why is it that we, as the wives, as the pregnant person, have to tell our husband anything? We still have about a handful of statutes right now that say basically you can't revoke your consent with your husband. So your husband can SA you all he wants. Like, we're already in pretty big trouble.
And like, here's my thing. It goes back to this, like, I say this for mostly our male guests, but female guests too. Like, if you cannot have an honest conversation about what is going on with you, with your spouse, listen, to Di's point, some people just, like, they're not comfortable, like, with certain technical things, and that's fine. But if you can't generally convey to them what's going on with you, statute or no statute, you have a serious issue. Listen, I'm not saying you have to tell each other everything. You don't have to tell each other what you ate for breakfast or lunch or whatever. That's crazy shit, right? Like, not all couples are the same. Or I won't say it's crazy because some couples do that, and it's probably great for them. But here's the thing. If you can't just have general conversations like, I'm pregnant and this is not the right time for us to have a baby, and like have a partner that's like willing to do whatever they need to do to help you keep that baby, or, support you in your choices, you got way bigger issues going on. Way bigger issues.
When we're dealing with rational basis review, we ask, whom does the law affect? And so it seems to me that you have to justify the law based on the effect of this 1% who would not otherwise know. And you may have an argument there. And it's a very strange argument to say that the law doesn't affect 90% of the people, so we're not concerned with the law. I've never heard that argument.
We're not in any way advocating that, because we think that the law is rational. If you look at the state interests that are trying to be pursued here, protecting the life of the unborn, protecting the marriage.
How does getting their mother beaten up protect the life of the unborn? I'll fucking wait.
May not advance it in every single instance, but that is not the test. The test is, does it generally rationally advance the interest that the state is trying to protect? In this instance, it does. By the sheer numbers that we have demonstrated.
General Pete, I thought we were talking
not rational basis, but undue burden. Are they the same thing?
No, they are not, Justice Scalia.
How do I go about determining whether it's an undue burden or not? What law books do I look to?
Well, this is a quantitative analysis, Justice Scalia, and you begin by ascertaining under undue burden the increase, whether it's a significant increase in cost such that it broadly impacts, it prohibits women from having abortion, or whether it bans abortion.
I suppose it depends on how important I would think it is that the husband of a wife know before a fetus that he co-generated be destroyed.
I think
would that be part of it?
That would be part of the analysis that's done in the weighing side after you establish whether or not there is, in fact, in the first instance, the threshold question is, what is the broad practical impact? If there is no broad practical impact, it's minimal, as is in Pennsylvania statute, then you reach the question of the weighing that's involved.
Well, it depends. I mean, if the impact is only minimal, but also the interest involved is only minimal, then I suppose it is an undue burden. And I guess that again leads you to how much weight you place on that kind of an interest.
As I understand it, Justice Scalia, what you're talking about is if there is no undue burden, that is, there's no broad practical impact in the initial analysis, then you determine whether or not the statute rationally furthers the state's interest. It's a rational basis test in the second phase of it. And under the rational basis test, which would be the same rational basis test that members of this court have applied in Webster, you come to the conclusion that Pennsylvania's spousal notice section does pass undue burden analysis, and it does pass rational basis analysis.
May I ask you a question about your understanding of the undue burden test? Do you think it refers to the number of persons burdened by the law on the one hand, or the severity of the burden on a particular individual affected by the law on the other hand? Which is the right analysis?
I think, Justice Stevens, that in the initial application, it's a quantitative analysis, whether there is a broad practical impact here. The fact that it
In other
might...
words, you say it's the number of persons affected is your answer.
The number of persons...
Regardless of how severe the burden on a particular individual.
As the test has been posited, the question of whether or not...
I'm just asking you to explain to me what your conception of the test that you're asking us to adopt is.
It may be that some women would be deterred to some degree, but that is not sufficient to create an undue burden.
It's the number of women affected.
Initially, it's the number of women affected, the broad practical impact of it.
We just deterred
as applied to a specific woman.
Absolutely not.
As applied to a specific woman. Let's say there is such a woman who has been battered and psychologically battered. And so the exception doesn't work in her instance.
Right. Let's
posit that. In that instance, of course, that's a worst-case scenario. That's not the way you test facial challenges. In that instance, the law would work. You would test the statute as applied in the lower courts, and that woman would then be...
And you'd apply an undue burden test there on the as-applied challenge, do you suppose?
No, I would think that you would be asking the court to give full rein to the interest that you have.
Okay, I put you up on the big screen, Di. What's up?
Just for a minute for a screenshot, if anyone was interested in the 3 levels of scrutiny, because they're talking a lot about rational. Intermediate doesn't come in until later, so I just thought if you wanted a quick screenshot of those tests, you can do it. And sorry to interrupt.
I love it. Everybody take a screenshot because honestly, I get confused between these sometimes too, but women get intermediate scrutiny and it's bullshit, and Di's going to start a feminist panel because we need to talk about
Heck yeah.
I love the penciled in portions at the bottom where the people always win with strict scrutiny. It's a toss up on intermediate and the government always wins on rational basis.
That's right.
Honestly, I never, oh my God,
gosh.
like, thank you for pointing that out because I didn't even notice the part on the bottom. I was looking at it like, No, but that's true. That's so fucking true.
Well, thanks for letting me show it.
Oh, absolutely.
Strict scrutiny is often called strict in scrutiny, fatal in fact, because the government can, no matter, it has to be narrowly tailored to match a compelling government interest. And no matter what the restriction is, you could always think of a slightly more narrow way to tailor it. And so the government just always loses.
It's
Like
a
almost every
beautiful
time.
thing.
The only time I ever saw them win it was the Korematsu case.
Yeah, that's correct. They had a compelling interest, but eventually Korematsu was overturned with the Hawaii case. Yeah.
Hey, by the way, real quick, as I totally bogart your life here, but is it crazy that just a footnote was put into the Hawaii case to overturn Korematsu from decades of problems? Ooh, it makes me mad. It just seems sloppy to me.
Yeah, it is sloppy. I'm glad it was officially done at some point. I mean, it had been done rhetorically for decades, but it was nice to get that official line in an opinion, even if it was a footnote.
Thomas be putting in, let's revisit this at a time. So I see that in at least one bigger decision from him a year. He's like, yeah, let's go ahead and let's go revisit this shit too. And I'm just like, you need to retire, Pookie. You need to retire. But I don't want to know who would replace him, though. That's the scarier part to me. Is like, I can't think of somebody like more Thomas than Thomas. And I can have a low-lying level of respect for him, even though I don't love most of his decisions, but because of, I like his writing, and his consistency. He may be consistent about shit I hate, but he's fucking consistent. I just can't think of who would replace him and what kind of horror show that might be. Administration, obviously, not like if we get somebody rational in office, but that's a horrifying thought. Any hoodle. Sorry, y'all.
The woman would have, under rational basis analysis test, a liberty interest protected by the 14th Amendment, or under the undue burden standard would have a limited right.
I would have thought you would look at the burden of the law as applied to the woman.
And I think that you would look to that, but you're asking the court in an as-applied mechanism to give full effect to your right. The statute given. It is a given that it burdens you. So you can't just look at the burden in the as-applied context, but you must look at it in that context at giving full rein to your right. And that's what the woman would be seeking from the district court or for a
Why
court of common pleas.
is he so angry? Did he do some blow before he got into court?
Applying this spousal notice section to her particular instance because she didn't have one of the exceptions to check off because she's psychologically or economically pressured.
But in the facial context, I don't understand what you. So there are two undue burden tests. There's one at the facial level, in which we consider the statute in gross and decide whether, all things considered, in the generality of applications, the burden's undue. And then we have a second wave of application of the undue burden test, case by case. So that even though the law facially may be okay, it may be invalid in its particular application because of is that what you're saying?
As in the second instance, as applied.
I'm worried about the first one, not the second one. I thought the way
facial challenge, Justice Scalia, you're looking at not the worst case scenario hypothesis, but whether this act could be applied constitutionally to anyone. And
any single case. Not in gross, to any single case. Isn't that the normal situation? To challenge a statute facially, you have to show that it can never be constitutionally applied. Isn't that right?
That's correct.
Well, but that's not looking at it in gross. That's asking whether there is any single case where a woman would not be unduly burdened.
In this particular instance, we find that there is no undue burden in our statute, anywhere in our statute. And if the undue burden
it's called
test
the Abortion
is
Control
applied or
Act.
Understood by this court causes our statute to fall, then we ask this court to adopt rational basis as the appropriate analysis.
You think that compelling speech requires any kind of First Amendment analysis?
Compelling
speech. The state is compelling a woman to say something to her husband.
We are asking that
does that invoke any First Amendment concerns?
Not in our view. This statute.
I would have thought perhaps compelling speech would get us right into a First Amendment area.
Super problematic.
In this particular instance, the statute we feel causes notification, but there's a legitimate state interest involved in furthering that interest.
There's
haven't told us what it
doctor
was.
To say certain things to the patient. Do you think that's really commercial speech?
Yes,
there?
I do, Justice O'Connor.
Why is that? When the doctor is giving professional advice to the patient, you think that's commercial?
That is commercial. The petitioners already do that right now. They already tell their patients, the physicians, and the counselors that there are medical risks associated with this procedure.
I wouldn't have thought that was commercial speech. What do you rely on?
And Zouderer.
But that's advertising. That's different.
In Pennsylvania's general informed consent law, applying to every single contact between a doctor and a patient, there is the same information that must be presented, and that is the doctor must tell the patient about the medical risks of the procedure and the alternatives to it.
Well, it might meet a First Amendment test, but I'm wondering how you get to commercial speech on that kind of advice.
Well, we think that there's with the interests involved, with the statute furthers those interests, and that it can legitimately require the husband to be notified because of the interests involved. I see that my time is running short, and I want to devote make sure the Solicitor General has some time to respond. We think that Pennsylvania has developed an intelligent statute that fully comports with the Due Process Clause of the 14th Amendment. It's a statute that's carefully drafted, and it's been amended to reflect the teachings of this Court's jurisprudence since Roe. We ask this Court to overturn Akron and Thornburg's strict scrutiny approach as being unwarranted, extended.
Interesting side note, just for everybody, because I was like, this man he did way too much of the book of sugar before he came into court. While he did not get popped on any smug charges that I found, he did get popped on mail fraud, and I rest my case.
Mentions of Roe on the facial challenge whereby the petitioners must show that there are no set of circumstances under which this provisions can be valid. Petitioners have utterly failed to do so, done in no small measure as the record demonstrates and is indicated in the Third Circuit Court of Appeals opinion by their own rational practices, which this statute mirrors.
Mr. Preet, because you have a little time left, there's one point on which I guess I never fully followed your argument, and I wonder if you'd go back to it. You got to the point, you were arguing about the number of instances, the percentage of instances in which the spousal notification would in fact make a difference in the behavior of the parties involved. And as I recall, you got it down to about 5% to begin with, who would not otherwise 5% of the women who would not otherwise give notice to their spouses. And then from that 5%, you subtracted some number for those, I guess, subject to medical emergencies, those subject to certification that they would be physically abused. And I think by that process of elimination, you got it down to about 1% who would actually be affected by the stricture of the statute. Is that right?
That is not correct, Justice.
Okay.
You start with the 1% because 95% of 20% is 1%. You're talking about 500 women.
Well, you're talking about all women, but the spousal notification applies only to married women.
That's correct. And so
what's the percentage of married women? Well, your time is up.
Sorry, thank you.
Thank you, Mr. Priet. General Starr, we'll hear from you.
Thank you, Mr. Chief Justice, and may it please the Court. In view of what has been discussed, let me address very briefly 3 points. The first is the standard of review, which has been the subject of considerable discussion. In a number of its cases over the last 20 years in the abortion area, The Court has articulated the governing standard of review in different ways. And as a result, there is confusion in the law as to how legislatures, if they choose, can legislate, and how judges are to judge in this extraordinarily sensitive and divisive area. In our view, the correct articulation of that standard is to be found in the Webster plurality opinion. That standard has deep roots. It finds its roots in a long line of due process cases that do not involve liberty interests which, by virtue of the nation's history and its legal traditions, rise to the level of fundamental rights to a free people. This is the process of analysis that is quite familiar to the Court, very lengthily laid out by Justice Harlan in his dissent in Poe v. Ullman, and then adumbrated in his concurring opinion in Griswold against Connecticut. Second, and relatedly, with all respect, we do not believe that stare decisis considerations weigh against the Court's providing that needed clarification as to the standard. This is not a new...
May I ask you one rather basic question that affects the standard review and everything else? What is the position of the Department of Justice on the question whether a fetus is a person within the meaning of the 14th Amendment?
We do not have a position on that question, and this Court
so we're
has
just in here wasting
not
your fucking
addressed,
time.
or at least there's no justice in this
in
Court.
It's addressed in Roe and decided.
That is correct.
That was a perfect
And it does seem to me
imitation.
that ultimately
Just
that is
saying.
an extraordinarily difficult question which this Court need not address, and it need not
I
address it in
understand
this
we need
case.
not address it. I'm just
We do not
curious
have a
to know,
position.
does the United States have a position on that question?
We do not, because we think it would be an extraordinary...
Imagine taking your dumb ass in there and not only so cases are normally there's two parties, right? But the Solicitor General can send in a notification and ask the Supreme Court if they can add in on a case, which we've seen multiple times from the Trump administration, because I think John Sauer's office may just personally hate me. But they're always arguing some dog shit. Usually when the government gets in on this shit, it's never good for anybody because they're just on one. But anyway, so he takes his raggedy ass in there and then he's like, no, we don't got a position on that. We're just hanging out and wasting the court's time for, I think he's going to have about 10 minutes up there before she goes into rebuttal. So just imagine wasting the court's time. I just have too much respect for people. Unless it was something I was really invested in, absolutely not. And this is still the Bush administration, Daddy Bush, not Bush Jr. So, that says all kinds of shit. But anyway, dragging his raggedy ass in here being like, we don't have a position on it. That's crazy shit.
Ordinarily
Well, and they've kept that
difficult.
position open because the government then doesn't box itself in. One thing that I thought was interesting too, how often the Equal Rights Act has come up and how we've almost got all the states to ratify, blah, 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 but then we had to bust it and it wasn't going to come together. And the big issue in the ERA had to do with gender and defining gender. It goes all the way back to that issue of our LGBTQIA plus community. That's what the language was that did it. And I find it really interesting then, as we keep going through more cases, that you can see all those same arguments over and over and over again that we're doing right now. It's just at a little bit different level.
No, they've gotten off these talking points. This just shows you how old these talking points are. We started with Griswold, which dealt with married people and contraception. By the way, just FYI, in the 60s, we were telling married people that they couldn't just choose not to have a baby. But anyway, sorry, my crotch goblin's running around right now. But
Hey,
anyway,
we have birth control though.
I
Birth
know.
control came out in that period of time, right?
Exactly. But we're seeing I make fun of it because I'm like, they must go and watch this for their talking points when they're talking about women. but these arguments are happening over and over again. And what it really comes down to, they kind of interfere with married couples sometimes, but married men are always on the way better end of that stick. Let's be so real about where that goes. The husband has to be notified, but you know, the woman just fuck her, because fuck them, that's why. But like at the end of the day, these arguments are recycled because they don't have anything better other than nuh-uh, it's a life. So I hope that makes sense for everybody.
And sensitive issue by virtue of a number of questions that would flow from that, including
Well, the
equal
court
protection
decided
and so
that
forth.
in Roe, did it not?
The court did, in fact, decide that there is a very keen interest on the part of the state in what the Roe court called potential life, and that's
yes,
my
but said the fetus is not a person under the 14th Amendment?
Well, I think that that is a necessary consequence of Roe v. Wade. But I think that the key point is that a number of the justices of this court have said that regardless of that legal question, that constitutional question, that the state does have a compelling interest in the potential life, in fetal life, and that interest runs throughout pregnancy.
And we did not say in Roe that a state could not have a position on whether a fetus is a person, did we?
Certainly
we said that the Constitution takes no position on whether a fetus is a person, or that it does take a position that a fetus is not protected by the Constitution.
The court seemed to admit of the possibility of state regulation to protect the unborn at all
including
stages.
State regulation on the basis of the people's determination within that state that a fetus is a person. There's nothing in Roe that says a state may not make that judgment if it wishes.
That it says that the state may, if it sees fit, that the state does have. I think Roe goes this far. Roe says that there is a legitimate interest of the state in the potential life in utero throughout pregnancy, and then the nature of that interest changes and becomes stronger over time. But it did, in fact, say that there is a legitimate interest, and there have been an expression by a number of the justices of this court to suggest that interest is indeed
Just
a
imagine
compelling
being this
interest on the
concerned
part
about
of the
what's
state.
going on in your neighbor's honeypot. Like, this is wild.
The government of the United States,
that
it is a compelling interest throughout pregnancy.
That is our position, that there is a compelling interest.
What is the textual basis for that position in the Constitution? Is there any?
Well, I think that, if I may, Justice Stevens, it seems to me that it goes to the recognition that we all do, that there is, in fact, an organism.
What is the textual basis in the Constitution? You argue very vigorously there's no textual basis supporting your opponent's position. What is the textual basis for your position? That there's a compelling interest in something that is not a person within the meaning of the 14th Amendment?
The state has
What is the textual basis?
The state has an interest in its potential citizen. It does not have to be granted a basis in the Constitution. Justice Stevens, it is my view that the state can look out and say, we, as we have historically, regulate and legislate in the interest of those who will come into being, who will be born. It is an interest that every member of this court has said in potential life.
That is a great question. My question is, what is the textual basis in the Constitution? If you're going to say there is none, fine. That's perfectly all right.
I think it's in the nature of our system, and if nothing else, the 10th Amendment, Justice Stevens, suggests
no, not the 10th.
That the state can order its relationships in ways that reflect the morality of the people within limits. There's a determination to... I'm sorry.
Why does there have to be something in the Constitution? There's nothing in the Constitution that requires the state to protect the environment, is there?
Of course not.
That can be a compelling state interest, may it not?
Yes. As I have said, the Constitution does not seek to order and to ordain. These are interests in which the state can have, and our nature of government...
All that Roe says is that the Constitution does not protect the fetus under the 14th Amendment. It does not say that a state may not choose to do so.
It doesn't even go so far.
Or that if a state chooses to do so, it is not a compelling state interest.
There's nothing in Roe that contradicts. I think, Justice Stevens, it is in fact the nature of our governmental structure. I do know of prohibitions that the Constitution sets forth. I do not know of particular provisions, other than indeed perhaps the 10th sheds light on this, that this is a matter that ultimately is, and I think this is quite important in terms of analyzing what Pennsylvania has done here. What Pennsylvania has said, in effect, is that we will not prohibit abortion, save for gender selection abortions.
We're just going to try to make it impossible.
Our colleagues on the other side believe that Roe v. Wade forbids that it protects that decision. It does not prohibit. It has seen fit to regulate. That is very much in the tradition of the Western democracies.
Standard, you started out to tell us what the standard was.
We believe it was articulated, Justice White, by the Webster plurality.
Well, what is it?
It is the rational basis standard. And that is the standard that has been articulated by this Court in a variety of decisions and by a variety of justices of this Court in its abortion.
And under that standard, you would think all of the provisions that are at issue here should be sustained?
Exactly.
And so would complete prohibition, wouldn't it?
Complete prohibition that had no exception for the life of the mother, I think, could raise very serious questions under the protection of life.
Subject to that exception, it would cover it would justify complete prohibition.
I think it best not to answer these in the abstract. We look to the specific.
We're going to circle up real quick. These are the dickheads that have yelled state rights for how many flipping years now? And now they're all federalists. Notice how Trump has transformed them into unitary executive theory. The Fed should control everything beasts. And they didn't even see it fucking coming. Okay, sorry. I didn't mean to get political, but, I thought it was funny.
Interests of the state as it has articulated those interests. For example,
I'll grant you that, but you're asking the Court to adopt a standard, and I think we ought to know where the standard would take us.
I think the rational basis standard would, in fact, allow considerable leeway to the states if it saw fit.
General, that's not really a fair answer. Rational basis, under your analysis, is an interest in preserving fetal life at all times during pregnancy. It's rational under your view. Ergo, it follows that a total prohibition protected by criminal penalties would be rational, would meet your standard.
I don't think so. The common law.
Then what is your rational basis standard if it's not the traditional one?
Ours is the traditional one, but under that traditional analysis, there must in fact be a rational connection with a legitimate state interest, and the state cannot proceed in an arbitrary and capricious fashion, in my view. If I may complete this, I think this is an important part of the answer. It would be arbitrary and capricious. It would moreover deprive an individual of her right to life if there were not an emergency exception, and even in Roe v. Wade, the Texas statute at issue there provided for that exception. It would be quite at war with our traditions as embodied in the common law not to provide at a minimum for that kind of exception.
But what you're saying is the rational basis standard, which normally just requires a reason that is legitimate to support it, can be overcome in some cases by countervailing interest, which is not the normal rational basis standard.
Well, may I respond? I think that the traditional rational basis test does in fact analyze the ends. It looks at the ends and the means, and it requires in fact that the state not conduct itself in an arbitrary and capricious fashion. That is the ultimate insight of the rational basis test. I thank the Court.
Thank you, General Starr. Ms. Colbert, you have 3 minutes remaining.
Mr. Chief Justice, I'd like to address 2 points very quickly. The first is in response to this last dialogue with General Starr. Recognition of a state's interest in fetal life as compelling throughout pregnancy would denigrate and restrict the ability of women at all stages of pregnancy to have an abortion. And certainly in the only exception that Mr. Starr and the Solicitor General has laid out for this court is in the very rare instance where only the life.
I was about to say the life of the mother exception. And I I can take a cue from abolitionists on this dog shit. I can. Because even when, I never understood how, okay, you're dedicated to life until. I understand it from a practical standpoint. Obviously, I believe in life of the mother and things like that. That's not an issue for me. But, it's like they can't pick a fucking struggle. What makes one life more valuable than the other? Because they're all life, according to you, right? They're all life. The mother's alive. The freaking your zygote is alive. So, what makes one life more valuable than the other? I'm gonna let her finish.
Oh my God, the zygote. No, not the zygote. I can't listen to that.
I swear. It just, it's, they can't pick a fucking struggle, man. What makes one life more valuable than the other to the chuds that argue from this position? I just don't get it.
I agree. I think part of it has to do with the moral issues you're dealing with, right?
Yeah.
It's immoral for an innocent, creature life to be, unalived versus if you're a kid and you're in a bad situation, you need lunch money. Well, figure out how to get yourself a job. I don't care if you're 8, there's just this moral element to it, in my humble opinion.
Well, and see, I think what comes up for me is when they make this argument, I can agree that everybody has subjective individual morals. It's not my job to dictate somebody else's. I mean, except for my children, I try to teach them good morals, but my neighbor, the people that they're generally talking about when they talk about this stuff, it's not my job to dictate anybody else's morals. And I feel like nobody ever ripped the Band-Aid off for them and told them that probably maybe one of the biggest things that's heartbreaking in working in law is that you find out real quick law and justice aren't always the same thing, and something can be immoral but also be quite legal. So I just feel like nobody ever ripped the Band-Aid off for these babies. So yeah.
Would be excluded from a ban. Bans of second trimester abortions, bans of certain classes of women having abortions, bans that would prevent women who have serious and long-lasting health needs to have abortions would be significantly approved by this court if the rational basis standard were adopted, precisely because of a formulation that the state's interest is compelling throughout pregnancy and sufficient to override any liberty interest, any interest of the woman to choose or not choose a pregnancy. And in fact, that is why this court must go back to the hallmark of Roe. That is, again reaffirm that the right to choose abortion is fundamental, and only when the government can show a compelling purpose, as recognized in Roe, that is, a compelling purpose after the point of viability, should it be able to sustain a statute. The second point I wanted to raise goes to the question of the rights by numbers approach articulated by the Commonwealth. It is our view that the husband notification statute applies to every single married woman in Pennsylvania, that the rights of autonomy, the rights of communication within the family, are infringed because those communications are subject to criminal prosecution and subject to independent district attorneys subpoenaing women and probing the communications between husband and wife.
Are there First Amendment values at stake there, do you think?
Your Honor, I do believe there are, not only in this section, but in the bias counseling provisions as well. Clearly, we've set forth in our brief why we believe this is not commercial speech. But in both instances, the court is forcing the physician to be the proponent of its ideology and also to communicate information about the abortion decision.
Thank you, Ms. Goldberg. The case is submitted. We'll hear
You know, people could talk all the shit about Rehnquist they want, and I'm sure they got valid things, but man, he ran a tight freaking ship. Like, he was like, we are not going over our time limits by 1 minute, and I'm here for it. Anyway, thoughts, y'all?
Well, I guess ultimately nobody really got what they wanted in the case. Planned Parenthood lost the strict scrutiny, and the contested provisions of the Pennsylvania law got struck down. So, we did end up with a reaffirmation of Roe's core holding, which I guess was good. They did away with the trimester framework and put in this undue burden test, which I think is more constitutionally defensible than the trimester framework. I just think that was pretty strong judicial legislation. That wasn't anything that was really bound in any sort of text or constitutional basis, but was more kind of a test of sorts that was created by the courts, but it was oddly specific to be a test. A test has questions that have to be answered by the court, and this was more of a prescriptive timeline, which doesn't really fall into the sort of test making that the court will do to see if a constitutional right is protected or violated in a particular case. But yeah, I don't think anybody really won this one, but we did get some clarity.
I agree. I do miss the trimester split. Now, I know it's weird, but if you put each piece together, first, second, third trimester, even just that very elementary perspective, I feel like it helped people understand the science and the medical piece of it, right? Because as you go through your different trimesters, then, it's growing up and so forth and getting ready to be born. And I felt like that made more sense to people than trying to figure out what's going on in all the business and, stuff like that. It could just be me because I don't get science, but I did appreciate that trimester analysis.
I think it was a good a good threshold. It was very clear, delineated, allowed for universal applicability, but I just think it was essentially an advisory opinion. It wasn't something that was presented to the court. It wasn't like a law was passed creating a trimester framework that the court upheld. They literally just kind of created it out of whole cloth.
Mm-hmm. Yep, I agree with that also. That's not the best either.
And for I'm not I'm not unwilling to embrace a trimester framework. Like I think anytime you're under 16 weeks, right? Like it's the first trimester. I don't think the state has any interest, right? Like that I don't think that they could demonstrate 1 ounce of interest they have in regulating that. As you get into the later, stages of your pregnancy, like it gets into a murky area in that second trimester between viability and non-viability. But you think like maybe the state can show interest there, right? Like especially when you're much later into your pregnancy, but also abortion doesn't work the way people generally think it works. Like you're not like 38 weeks and they're going in there with people like to use like a blender. That's not what happens. You have to birth that child. If that child is born and survives, then they pass away. Like I don't know. I'm not okay with the trimester framework, but yeah, I think it does make it easier for most people to understand.
I feel like it pulls away the religious elements too,
Yeah.
because it seems again like we're like what you're saying, Law, we're legislating from the bench. That's not a great look, which is true, but also it has this kind of sterility point, I guess, where we're not talking about moral obligations here. We're literally talking about, like what Beth was saying in the comments, like weeks and days and so on. So it pulls that religious element out of it, and I appreciated that too. I'm not sure how we're going to get religion out of it, but it was like at least trying to.
Yeah, well, I'm always a fan of objective measurements, like it because it's a yes or no question. You don't have to do any analysis. It's if this, then that, and
Yes.
even when we're talking about the trimester framework, like it was something like 80%, 85% of all abortions happen in the first trimester. So even if we just accept that, we've eliminated like 85% of the controversy. And then something like 99% happen before 20 weeks. So, when we're halfway through the second trimester, I guess even a third of the way through the second trimester, we've already eliminated 99% of the controversy. And then what's left is, valuable and worth fighting over. But if we can at least settle 99% of the controversy, I'm a big fan of that.
Well, and I'm supposed to just kind of sprinkle this in here. It's probably going to be very controversial, so I'm going to speak quietly about it. But oh wait, hold on. What were you just saying? I just lost it. Hold on.
Sorry, Law. Go ahead.
I wasn't saying anything.
Oh no, objective view of the law is what you're saying. Oh my gosh, I just lost. I'm sorry, everybody.
No, yeah,
bubble
I
popped.
I like objective metrics. It's if this happened, then it's okay or it's not okay. Like a speed limit. If if you're going under 55, you're not speeding. If you're going over 55, you're speeding. It's objective. It's not open for interpretation or argument.
Yeah, I still forgot it. Sorry.
I would say, I guess it's because of the situation I am currently in my state. If my state had been like, anything in the first trimester, you're good, right? Like up to that sort of 15-week mark, right? And then, beyond that, we're going to have, stricter enforcement about X, Y, and Z. I wouldn't have said that was a great take, but I would have been okay with that. It's that we're at this very dangerous level of states with like 6 weeks. A lot of women don't even know that they're pregnant at 6 weeks. Like, that's the problem. That's the whole crux of the issue here. A lot of women don't have regular cycles. They've got other stuff going on. They may not notice that they're late because we're busy and we do things and we work for a living. Like, I just find it insane, like, that the take is just basically when we kind of come back and we're going to go to Dobbs on Friday, everybody. We will review Dobbs on Friday. But stuff like this, rolling back some of the standard, like the strict scrutiny, and then it took 50 years for them to say women can do what they want with their body to no, they fucking can't. That's a really condensed time frame for women to go from you can't do anything to now you're good, and then back to, well, maybe we need to think about this, and then fuck you.
Well, yeah, the very short period of time. And I think, too, this whole idea during this, after Roe was passed, we had just gotten birth control. That was great. But we didn't know how Roe was going to affect the people, right? It takes a few years for the SCOTUS cases to actually get out into the U.S. and have the effects that it was having. So, like, we didn't even really sink our teeth into Roe before Casey came along, in my humble opinion. We didn't have enough time for it because it happened too quick.
Yeah, and just like, I don't know, it's the thought that even in the 90s, right? I was born in 86. What was this? 92, 93? States were still having the audacity to tell a married woman. Like, honestly, I don't think that they highlighted enough what my girl Sandra Day O'Connor was like on his neck about, which is like, how are you going to compel somebody's speech? Like, how are you going to tell somebody that they have to tell their husband? Like, that's crazy. I would have stayed on that, but I'm an asshole that way. But I thought that was interesting that you pointed it out, and I
Great
never would have
point.
thought about it that way. It was a good way to frame it. And I know they rolled back that provision, and I get that, but I just, it was, I don't, this
It was a
just,
really big deal, really, really big deal when Casey came down. I mean, I was, conscious at that age. I was only 2 months old. No. It was a huge deal, actually. And I remember going through at that point because we had to do reports on different things and thinking, so I was like in middle school, I think. And I just went home to my mom and I'm like, Mom, they took Roe away with the Casey case. And then I had to do this whole presentation. And I was like, I feel really bad. Nobody understands that Roe's almost not here anymore. And my mom's like, you're right. And then today, yeah, we're still there. We still don't have that protection
no,
that I had
Roe's
hoped.
absolutely fucking annihilated. Like, it's,
Yeah,
I swear to
yeah.
God. And here's the thing. I always tell people, if you want to be pro-life, I absolutely support your decision in that. For me personally, I am like, it's not a decision I'm going to make barring medical or just something horrifying happening to me, right? Like, that's not something I would do. However, I have zero business telling anybody else what to do with their honeypot. If they want to, if my neighbor wants to go yeetus their fetus, it's none of my fucking business. And more importantly, it's none of the government's business. That decision should be between a woman and the medical professional who knows what the hell they're doing.
Oh my gosh, I just remembered what I was going to say. Oh my gosh, just from what you were saying. Another piece to that is, if you look at the countries where abortion's the primary, or ABs are the primary birth control element, for example, Russia, right? So you would just go in, get her done, and then go back home. It was no big deal. But one of the things that I think is really interesting, again, people are forgetting this is a medical question, is like, so, people aren't going in for 3, 4, 5 ABs over a short period of time because it's easier than protection on the front end of that. But also, over time, this many ABs and even going forward can absolutely have huge negative impacts on your uterus. Like, you can't keep doing that. You can't go in and get an AB once a year for 5 years. Your uterus won't work anymore. And so then now we're back into the world of the doctor, where the doctor's like, I'm not saying you don't have a choice. I'm just saying your uterus doesn't have a choice here. And so respect that. And that was another piece that seemed to be a bit of comfort, to be able to say you can't just go in and have 50 of these because it's not good for your body. So, there's another little tiny medical check as well. And I had forgotten. So there you go.
Listen, Barta put some in the comments, and I've said this before too. I feel like brain folks get more rights to their bodily autonomy than like women in my state do, right? I can't
They
just
still get to be senators.
True.
It's true. Yeah, it's true.
But they get more autonomy than people who are donating organs and blood get more autonomy than women do with what happens inside their own body. Like, you can't demand somebody deliver an organ, right? Like, they has to be like a willing donor. Like, if that person's now, if they're their family has to consent. Like, that's what has to occur. Those are the things that have to go down. I know we have different rules with like people have the donation stuff on their cards and stuff. I'm not getting into the complexities of that, but generally, the family's going to need to sign off on something. They need to be notified, da-da-da.
What if the dad's the father?
Oh, that's
the road that is so difficult to go down, is it's not just about, with the Casey case, it's not just about, well, the guys have some kind of an interest in it as well. It's that, you're not going to be allowed to have one until the father of the baby or your dad signs off on it. And if they don't, then you're being denied the ability to have one. And so whoever hurt you, that baby you're going to have to carry to term.
Listen, in the year of our Lord, 2026, AK after Kirk, and it's about to be AM after Mitch once they actually announce that. Women should not have to fight for the right to control what happens to their own body, at least at a bare minimum, pre-viability. Should definitely not have to be fighting for that right now. Post-viability, I could maybe see a state making a reasonable argument that they have some sort of narrow and tailored interest there. But let's just go with pre-viability. In the year of our Lord, 2026, AKAM, because we all already know, you should not have to do that. It's so simple. If you don't like abortion, don't get one. If you're a man that doesn't like abortion, to Law's point, and he says it all the time, don't fuck pro-choice women. Your stuff is solved. Oh, what's that, Attorney Di?
Oh my gosh. Sorry, I'm not really paying attention. That last piece. I'm sure it was amazing, Cass. Sorry, this is my first box of Neils. I just spread them out here on my table because I got to pick which ones. Because we got to get this feminism roundtable going on here.
Heck yeah, I'm going to get my nails done this weekend. Let's do it.
Okay, sorry about that. That was a bit rude. I just wanted to see how the camera got the different colors. I may not actually be awake right now. This may be me walking around sleeping. I won't know until tomorrow, so I apologize.
Well, you're good. I won't know anything until I have to go back to the dentist tomorrow because they have to, I don't know, do something. So I'm like, okay, I'll be back in the morning. So I am probably going to wrap it up here in a few minutes, but do y'all have any final thoughts you'd like to leave us with? Also, everybody in the comments, we're going to be doing Dobbs on Friday. So we'll be back with Dobbs on Friday. I'm taking tomorrow off because, yeah.
You need it. You've been working hard out here. Here's my question, though, for Dobbs. The case itself, right? But what about the dissent? The dissent that's written in there goes and basically does like some Nostradamus stuff of predicting what'll happen to our culture and how the U.S. Supreme Court will lose all credibility and there could be an uprising. Worth a look. Don't need to do it, but I just wanted to remind you that that is in this case.
Yeah, we can look at the dissent. I'm here for it. Yeah, let's do it. Law, do you have any final thoughts on?
No, I think I covered everything. So thanks for doing this as always.
Oh yeah, thank you for being
Have you already
here.
put your chickens? Have your chickens been put to bed already?
They are. Little Nuggets doing good, staying under mom. Mom's being good and not pecking their babies as they do sometimes. So that's always a win.
I meant to ask you about the baby chicken earlier and I got distracted at the dentist and I texted you about that instead. I was like, I fucking hate the dentist. But anyway, Attorney Di, you got any final thoughts for us before our wild feminism panel we're gonna have? Because fuck these men.
I'm so happy that you're doing these cases, I guess is what I would say. You're probably looking at your numbers and you're like, well, they're not huge numbers, but that's not what's needed. It's the conversation that's needed. And then the numbers can pass to each other. But I remember trying to just jump in with the Dobbs case and nobody understood what I was talking about. So the way that you've set this series up has been, I think, what's going to make it so enormously beneficial for a lot of people. So I'm hoping you'll make this into a playlist because I think it can be referred to quite a bit.
I do actually like on my YouTube all the lives go over there. So far what I did, like I started with firearms because, why not? So I did the big firearms cases, Heller, McDonald, Catano, Bruin, and Rahimi. And then now I'm doing women's rights. So we did the Griswold, Eisenstadt, Roe, Casey, and then we're going to do Dobbs. So try to kind of put them together in groups of like 3 to 5, depending on what type of case it is. And then the next one we're going to go into once I get back from vacation is free speech. We're going to have Brandenburg, Reed v. Town of Gilbert, Virginia v. Black, Texas v. Johnson, and Engel versus Vitale. So,
What do we think about Tinker?
Tinker?
Symbolic speech, black
Yeah.
armband? Or
Black
is that-
armbands
I
in
can-
Iowa schools.
I will add that in. Hold on. I was gonna do more specific like school related cases, so that
Ooh,
actually
you could
may
do
be
that.
in there with my specific to like K through 12 college student type like cases that condense into that. But I can throw Tinker in there. I'm good.
No, I like that one. Doing Tinker, and then you can have Angry Cheerleader, Brenberg School District.
Right.
That's a great one.
The field praying. What was that one? That was just a couple days or a couple years ago.
Coach, the praying coach. God, what was it? That one.
I
Like
remember that one, but I
Bromberg?
don't remember the dang name right now. And I
Is that Bremerton?
Bremerton. Yeah, that sounds right.
okay,
Ooh,
yeah.
and what about the Alaska one when the kids were like, hey, bong hits for Jesus? That's a good one.
Hell
Yes.
yes.
Bong Hits for Jesus is a great case.
Or
Oh
the
my
last
God,
one
hold
that's
on.
when
I
they
got-
did a valedictorian speech and he's like, my wanger's really big and happy, That's a good one too.
Okay, listen.
I didn't say that one, but
I
didn't say
gotta
that very
put that
last
in
time.
my notes. Bong hits for Jesus. I have never heard of that case, but I support their struggle. We will be doing that one no matter what when I roll into school cases. Bong hits.
Oh, the
for
Hustler. What
Jesus.
about Hustler too?
Oh
do a whole
yeah,
thing
I
on-
do. I do have the defamation cases. Like I'm putting together like all of those like in a similar structure. So yeah, we're definitely doing that one.
Cass, you're amazing. Look at you going through
Listen,
and
I
setting
need
this
to
up.
send you the list too. Law has the list, and I don't know what like 60 or so cases on there that I'm like putting into groups, but I'm always willing to look to like add a few more if I can, as long as it's not like 30 cases on one particular subject. That'd be a little overwhelming for people. But I'm trying to add in like either really interesting, they don't essentially have to be a landmark case, but something that shows how these cases build on each other is also really important to me. Like showing how Eisenstadt and Roe took from Griswold, like stuff like that. I always I prefer that. But yeah. So free speech we'll be doing when I get back from vacation, and then we'll roll into all the other categories I have. We're still it's a working list, so we may have more
love
stuff
it.
added. But anyway, you guys, did y'all have any other words? Are we good to go tonight? Sweet. Okay, guys. All right. Well, I'm going to get out of here because it's getting late and I got a dentist appointment early in the morning. But Law, thank you so much for being here. I really appreciate you. Attorney Di, I appreciate you as always. Thank y'all both so much for coming in. Everybody in the comments, y'all are amazing. I'll be back with Dobbs on Friday. And I love you all. Have a good night, guys. Bye.
You too.
Good night.
Night, night.
Bye.